My name is Olaide Banks, and I am an attorney with the law firm of Ngwolo Banks. And over the next few minutes, I will share some thoughts and insights to help you to get on the road to peace of mind. For most of our adult lives, we work hard to reach our goal of financial freedom for ourselves and for the ones we love. Whether we've reached the goal or we're still working our way there, we want to be responsible, we want to be prepared, and we want to leave a legacy for the ones we love. By taking the time to create a will and an estate plan, you put yourself in unique company. You become part of the minority of Americans who take charge of their financial future and use the power that has been granted by the law to make important decisions to help the people they love. By creating your estate plan, you even have the opportunity to provide for your own financial needs later in life. To create a will, all you need to be is of sound mind and to have what we call testamentary capacity. That means the person must understand the general nature of their property and the fact that they're about to create a will. So many people are paralyzed by the thought of creating a will. I have close friends and relatives who say to me, I know that I should have a will, but I just hate to think about it. Other people say, I don't have a lot of assets, so I really don't need a will. I usually say to these people that you don't need to be a millionaire. You just need to be the kind of person who wants to have a say in what happens to the things that they've worked for all these years. I also know that there are some people who don't make a will or plan their estate because they feel uncomfortable making decisions or don't want to make difficult decisions. But decisions are truly the pathway to power, and you are never more empowered than when you make the decisions to provide for the people you love. Many times it takes a life-changing event to spur people to create a will or to begin planning their estate. For some, that event might involve the birth of a child, the death of a loved one, or maybe a close friend or classmate gets seriously ill. Whatever it takes to get you to take that first step of responsibility and create the plan can only be a good thing. But it's important that the decision is not just an emotional one. A Texas young lawyer's report showed that each year in Texas alone, thousands of consumers fall prey to con artists peddling living trust scams. Now, you might see these on TV, or you may get emails, or you may hear something on the radio, but people over the age of 50 are the most frequently targeted and lose between $500 and $5,000 each on these scams. The main selling points that these scams use include statements that living trusts save money on taxes, or that living trusts help people qualify for public assistance benefits, or that living trusts avoid lengthy or expensive probate. Now, these sales pitches include false and misleading information. They're dangerous because in most cases the consumers just buy a set of forms and never actually meet the person who created the forms. The key is to do your own research and to get to know the person that you'll be working with, and then don't be pressured into making a rushed decision. When you visit an attorney to discuss your will or estate plan, he or she should listen to you and hear about your unique situation, and then they should ask you a lot of questions. Now, based on your conversation and maybe a questionnaire that you take away from the office, your attorney will have most of what they will need to help you put your plan in place. Everything that you say to your attorney is confidential. And your attorney will probably ask you some very personal family questions that may make you a little uncomfortable. I know I'd be uncomfortable answering some of these questions. For example, are there any children outside of your marriage? Are there children and siblings who may not be on speaking terms? But the answer to these questions help your attorney to plan for and avoid disputes and potential will contests. You need to choose an attorney who makes you feel comfortable and one you can trust. Before your attorney begins to put your plan in place, they have to understand who and what are most important to you. They need to understand your goals and wishes. For example, they need to know, who would you like to be your beneficiaries? Who do you trust to carry out your wishes upon your death? What do you own of financial or sentimental value? Do you have young children? These are just a few questions that your attorney will ask to help him or her to help you create the best plan for you. When you're open and clear with your attorney about your goals and wishes, your attorney can work quickly to help you. By now, we've all heard of the statistics that more than half of marriages end in divorce, meaning that the likelihood of step families and other relationships that may not have been traditionally major concerns in our probate system are now more prevalent. Some states recognize gay marriages and civil unions, but the future development of the law in those areas is still unclear. Your will and estate plan can help clarify these issues. The issue of taxes is something that makes many people cringe. Now, you've all heard the only two things certain in life, death and taxes. And you've probably heard of the death tax. Now, the real name for the death tax is the estate tax. In reality, the estate tax only impacts individuals who have a net worth in their estate of over $2 million, or for a married couple, that would be $4 million. But with some basic planning, even high net worth individuals can significantly reduce their potential estate tax liability. As baby boomers age, experts say that Americans over the age of 55 will make up a greater percentage of the population than at any time in the past. The generation that provided for the needs of their parents in retirement and who are currently putting their own children through college now face the challenge of providing for their own care in an uncertain future. An estate planning attorney can assist the client in preparing for the legal and financial issues facing today's seniors. One of the issues facing not only seniors but even younger couples is the need to provide for the long-term care of a disabled person. A comprehensive estate plan addresses the issues related to short-term and long-term disability for the client or even for loved ones. And I can assure you that the process of creating a will and an estate plan is empowering and will provide you with a peace of mind that you had never imagined.